You are welcome to yet another episode of HN What's Your Say? The #1 listening show where we discuss real issues with real people like you. We are still featuring R. Kelly. Real name, Robert Sylvester Kelly. Also known as the R&B King. Right from the time R. Kelly was arrested, his rights have been violated in many ways. Among the issues R. Kelly has had to deal with while in prison is the violation of his client-attorney privacy right, among others. Everyone interested in the R. Kelly case knows well that during the period he was first held at the Chicago Metropolitan Detention Center, what was supposed to be his private information was leaked to a popular social media blogger who goes by the screen name Tasha K. According to reports, an FBI investigation was launched during which a laptop and other devices were seized from one of the Bureau of Prisons officers, who was suspected to have tapped and recorded R. Kelly's phone calls to his attorney, emails, visitors' logs and other restricted information during R. Kelly's stay at the MCC. Even if the Bureau of Prisons was to give excuse after excuse for doing this, their hands are completely tied on this, considering the female officer involved at that time worked as a disciplinary hearing officer at a prison in Wisconsin, and had not been deployed at the Chicago MCC. This means she was only at the MCC and involved in this case solely for the purpose of spying on R. Kelly. The FBI determined that the officer managed to access R. Kelly's records more than 150 times during the 6-month period he spent detained at the Chicago MCC. Another finding that confirms the officer's core mission was to steal this information is the fact that she made sure to email herself a 12-page scan of Kelly's jail records before she prematurely retired in December of 2019. The move to quickly retire her also serves to prove that the conspiracy to access R. Kelly's conversations with his attorney was not simply a dealing between the officer and the social media blogger, but one where the government was heavily involved, perhaps to get information to use against Robert at trial. During this same period, YouTube blogger Tasha K boasted she was receiving top-secret information about R. Kelly. In her own words, she bragged, "Yeah, there is a phone tap somewhere and I am gonna tell you where it's at. I've got the plug and sure, I will tell you where the information is coming from. But for now just listen to the damn information. Okay?" According to the investigation findings, Tasha K did read out word for word with precision, and made public information only the Bureau of Prisons officer would have known. It's clear the prison officer was working for the government, and probably leaked some information to the blogger just to earn an extra monetary bonus, or perhaps to throw the investigation off track so that the government prosecution is not implicated as an interested party. No wonder they tried to cover up by prematurely retiring the officer like they always do those found to have acted against the law. Remember the notorious Angel Kroll who messaged witnesses suggestively was also relocated and reassigned a new role elsewhere. The government is definitely afraid of the implications this notorious act may have on their credibility, and of course on the fate of the entire case. If it meant retiring the erroneous officer in order to hush this up, they would do it, and so they did. By tapping R. Kelly's phone calls and email conversations with his attorney, the government violated his amendment rights that provide for client-attorney privacy. To be specific, the First, Third, Fourth, Fifth and Ninth Amendments. An accused person has the right to either admit or deny guilt at their will, and to confide in their attorney without interference from the government. But R. Kelly was denied this freedom when his information was catfished by government itself. We cannot deny the possibility that by making use of information obtained through this illegal method, the government could have determined who to call to the stand to testify and who to leave out, intimidated the witnesses with threats of possible indictment, and forced them to testify against R. Kelly in exchange for their freedom. No wonder we saw some of the prosecution witnesses tearing on the stand, and ending by reminding R. Kelly how they still loved him anyway. This is typical of a person who believes one thing, yet conditioned to do another thing altogether. No wonder we saw some of the witnesses such as Lisa Van Allen dragged to court by the feds and forced to testify like the government had something on her that made her indebted to them. The sudden change from defending R. Kelly to testifying against him among these women could also be explained by this. Now we know this could be the reason R. Kelly was duly denied bail over weak non-judicial arguments that he was a flight risk. They could have done this to keep him in jail where they could listen to his conversations and use them to implicate him during trial, as well as to blackmail the witnesses. Of course, if he had been in his own space, the government would not have succeeded with this malicious act of sabotage. They needed to keep him under their eye and gather as much information as possible. It is sad to learn that the government has extended its impunity to the prisons department, and is now illegally using the institution as an evidence-gathering apparatus. If an inmate cannot feel safe and protected in prison, then the U.S. prisoner has been completely stripped of all their rights and left with nothing. The right to privacy with their attorney was the only thing left for a prisoner to depend on and hope to regain their freedom. When this is taken away, all inmates need to brace for a life in prison with no hope of acquittal, or even a reduced sentence. The Higher Court of Appeal, however, is mandated to look into such case complications in order to determine whether such infringements did occur, upon which they are supposed to immediately dismiss a case, or return the matter to the lower court for a retrial. When the R. Kelly case goes to appeal, therefore, we are more than likely to see an immediate dismissal, considering a leak of such information makes all prosecution evidence null and void. Even if a retrial was recommended, it would be meaningless considering the witnesses are already intimidated and therefore compromised. There is no way for them to give meaningful testimonies if the government has something on them. All the court is left to do, therefore, is dismiss the charges and order the immediate release of the defendant. Another strange thing to note about this issue is the fact that until now, ever since the prison's officer carried out this illegal act, she has never been brought to book. It looks like retiring her early was a government attempt to indemnify her actions, and probably make us forget about this dubious act, but we won't. Why is the government even protecting her? If they have nothing to do with her actions, why can't she be subpoenaed and questioned so she can demystify this situation? According to Donnell, I always had the feeling that government is hiding this Bureau of Prisons officer who spied on R. Kelly while in jail. And for this, the case should be dismissed with prejudice, and thrown out the window completely. If you wish to take part in a live interview on this channel discussing any of these topics, let us know by emailing us on sashahnnewsroom@gmail.com for scheduling. That is all we had for you today on HN What's Your Say? To keep updated whenever we post a new video, subscribe to this channel now. Also remember to hit the bell icon and enable notifications. And feel free to share your opinions with us in the comment section below, and let us know if you would like us to publish your views in our next release. We value all our subscribers' opinions.